Afternoon, everyone.
Good afternoon.
This is the matter of Maricopa County Libertarian Party versus Maricopa County et al. CB 2021-002205. Counsel for the plaintiff, would you state your appearance, please?
Good afternoon, Judge. Attorney Michael Pilsky, on behalf of the plaintiff, the Maricopa County Libertarian Party.
All right, thank you. And counsel for Maricopa County, and I'm assuming all of the defendants.
Yes, Your Honor. Joe LaRue, and with me, my colleague, Emily Krager. We represent the Maricopa County Attorney, Alistair Adele, here today representing all Maricopa County defendants.
All right, very good. Is there anyone else who needs to make an appearance today? All right, very good. This is time set for argument on the motion to dismiss. Anything to address before we jump in with the argument for the plaintiff?
No, I don't think so, Judge.
All right, for the defendants?
Your Honor, just one thing, housekeeping matter. I see some guests on the line, and I just want to be sure that the only amicus brief that was filed in this matter was filed by the Arizona Republican Party attorney Alexander Collin. Is that correct? Did any of the guests file an amicus brief?
I don't have any other amicus that I've seen filed with the court. That's the only one I've granted authorization to file a brief and have accepted their brief. So that's the only one I'm aware of. If someone filed one late, I'm not aware of it, and I haven't authorized anything else to be considered at this time.
Okay, thank you, Your Honor.
All right.
That's all for me.
All right, very good. This is time set for the motion to dismiss. This is the county's motion. Who's going to argue?
I will, Your Honor.
All right, Mr. LaRue, you may proceed.
Thank you, Your Honor. And
Let
may please.
me just ask one more housekeeping matter. It's not your turn to talk. If you would please mute your microphone, that'll prevent any extraneous background noise from interfering with the proceedings.
Thank you, Your Honor.
All right.
May it please the court. I have just two very quick points to make, and then I'll be happy to take any questions that Your Honor may have. As we said in our papers, this matter should be dismissed for two reasons. First, there's no legal right that the Libertarian Party has to attend the audits that occurred in February. The statutes that address political party attendance all have to do with the audits that occur right at the time of the election, when the political parties have an interest because they have candidates on the ballot. But this audit that was conducted by the county in February was a different type of audit. It wasn't contemplated by Title 16 or by the Elections Procedures Manual. It was authorized by Title 11, the general governance power of the Board of Supervisors, and it's just different. So they don't have a legal right to attend, therefore they don't state a claim. The second reason that the court should dismiss is because the matter's moot. It was moot shortly after they filed the lawsuit. It was moot 2 days before the order to show cause hearing in this matter. The audits are done, and there's just simply no relief that the court can grant that they've requested. And so for those reasons, Your Honor, the court should dismiss this matter. And with that, I'll be happy to take any questions. Otherwise, I'll reserve any remaining time that I may have for rebuttal.
All right, thank you. I don't have any questions at this time. I'll turn it over to the plaintiff, Mr. Kilsky.
And Judge, I appreciate Mr. LaRue's brevity, and I will try to match that. Judge, I disagree on both points that Mr. LaRue, on behalf of the defendants, presented. And I just want to urge the court to take guidance from the recent Arizona Supreme Court decision in the Arizona Public Integrity Alliance v. Fontes that was decided November 5, 2020. And it makes the following points, and those points are critical to the court here analyzing this case, the motion to dismiss as well as the claims of plaintiffs. Election law is statutory. The officials only have those powers prescribed by law or enjoined from acts beyond that power. And it is beyond the pale to for the defendants to argue that, well, essentially, Judge, we derive our power to do what we want here under a kind of a generic power under the Board of Supervisors, when in fact the laws that govern elections and everything surrounding elections are strictly prescribed by statute and are the laws and those things that have the force and effect of law, the Election Procedures Manual, that govern all these procedures. And again, Judge, I don't make this argument lightly, but what the defendants have basically argued is that we're outside of the Elections Procedure Manual. We're outside of statutory powers dealing with elections law, just because this is directly related to elections, just because this involves election equipment, just because this involves the results of a recently conducted elections, doesn't mean it has anything to do with election law, and so therefore we're under some kind of a general power. And I think that's it's just pushing it too far, Judge. And again, I urge the court to take its time to review what the Arizona Supreme Court has told us about the powers and of public officials, and that the public officials only have those powers, in fact, that they have been delegated. And here that they have, as we've argued, they have exceeded that power. We have brought a claim pursuant to the statutes that require the counties, as they're dealing with election law matters, require that the counties invite the political parties to provide their oversight function, which is a critical component of pretty much every element within the Elections Procedures Manual, as laid out by statute, as laid out by the Election Procedures Manual. And again, without getting into the nitty-gritty detail, we've laid it out in our pleadings, we've laid it out in our complaint, and while the county touches on some of that, the county chooses to reinterpret some of the plain language there in a way that I think just turns some of it on its head. And as you just heard, the county says, well, this isn't even an elections matter. This is some general power that the Board of Supervisors has that's outside of elections. And again, it's just appalling, because the evidence shows, Judge, and as we've tried to argue in our pleadings, and as we've tried to show, from the beginning, it was always supposed to involve political parties. The Board of Supervisors, in their meeting on January 27, 2021, approved these forensic audits with the clear intent to include the political parties. The political party representatives, though, ultimately were prohibited by the defendants from participating, despite the mandate of the board that even authorized this. And the public notice on that same day, January 27, 2021, makes that clear. We referenced that. Members of all three political parties will be invited, and they didn't do that. On the public notice that they repeated, again, in their public notice of February 25, 2021, they stated that political party representatives had been invited, even though we were banned. And in a presentation that Scott Jarrett, the co-elections director for Maricopa County, made to the Board of Supervisors on February 24th. Again, this is all, I'm just making reference to things that the court may take judicial notice of, because these are all public records. The co-elections director told the Board of Supervisors at an official Board of Supervisors meeting, we sent out invitations to all those parties. Again, That's not what happened. And so, Judge, we're asking the court for relief based not only on the requirements of law, but also, I apologize, try to mute that. But also based on, not only based on the requirements of the law, the statutes, and the elections procedures manual, but also based on the defendant's own public statements, both before and after, when they repeatedly said that the political parties would be participants and would be invited, and they even stated after the fact, even though they knew that we had been excluded, they, in their public pronouncements, they stated that we had been invited, and that was true. The relief we're asking from this court is very simple, and this goes to the mootness claim. And as we've explained, Judge, and as I think the court has already somewhat held on a preliminary basis, I think the defendants are not going to be given much leeway or latitude regarding a mootness claim, because we did bring this action in time. For reasons beyond our control, the court scheduled the first return hearing on a date that, as it turned out, was immediately after the defendants here, as we argued, rushed to complete that audit before that return hearing could even be held. And Judge, if you remember, and again, I want to turn to this because this is critical. On February 17th, at that first return hearing, counsel for the county, Mr. Ruru, even told the court explicitly that the county was not even conducting that audit. And that was the first thing he said, even the day after the supposed audit had concluded. And Judge, I'm going to ask the court to hold the defendants to that assertion that it made to the court, that there was no audit, and that the relief we're asking for this court is to declare those audits null and void, of no effect whatsoever, because they were conducted in violation of the law, and to the extent that the court, under the legal authority where the court may issue orders in matters where the claim is capable of repetition in their evading review standard. Again, we would ask the court to also issue injunctive relief that orders the county to never, in the future, should they want to redo this misbegotten supposed audit and want to do it right with political parties observers invited, that they must invite political parties observers as required by statute and as required by the election procedure manual. And again, for all those reasons, A, this is not moot, and B, the relief that we're asking, the declaratory relief, that these be declared by the court as having being void and having no effect of law or whatsoever, because they were conducted in violation of law. And because of all the public pronouncements the defendants made here, saying that they were inviting the political parties and that they had invited political parties, which turned out to be completely false, the county should be held to a higher standard. And the county should be held to the standard that they must follow the law. The officers of the county, the elected officials and other appointed officers, only have those powers that are delegated to them and not other powers. We ask that the defendant's motion to dismiss be denied, and we ask that the court summarily rule in our favor based on everything the court already understands now about this, based on the pleadings that have been presented and the exhibits attached. Thank you, Judge.
All right, thank you. Mr. Kelson, one question. In your response to the motion to dismiss, the plaintiff relied, it seemed to me, exclusively on the Secretary of State's election manual. Is that the sole basis for the defense of the motion?
No, again, Judge, as we've argued, and again, as we stated in our motion, in our response to the plaintiff's motion, that the responses included by the memorandum set forth there, but also the complete docket and record, all of which are incorporated. So the court not only can rely on or refer to our response, but also refer to our original pleadings in this matter. And again, as we made clear in the pleadings, yes, the election procedures manual is a core of this, but it's more than the elections procedures manual. It's the statutory basis of that. It is the law of the state of Arizona. Again, I just referred the court to the Fontes matter from decided by the Arizona Supreme Court, November 5th, 2020. I think which lays out the standards that are applicable in this kind of case. And so I don't want to let the court believe that it can solely rely on our response pleading, but it should rely on the entire record in this case to decide the defendant's motion to dismiss. And as I said, I think the motion to dismiss should be denied and judgment granted to plaintiffs.
Thank you, Mr. Gilson. Mr. LaRue?
Thank you, Your Honor. Just a few things in rebuttal. First, I want to be clear. The court can, I'm sure, pull the audio recording of the order to show cause hearing. I never said that there wasn't an audit occurring. What I said was there wasn't an audit of the election pursuant to Title 16 that was occurring. My colleague, Ms. Krager, made that point clear in the last hearing that the court had. And as I said, it's on the audio tape. The court can listen to that. But at no point in time have we ever said there wasn't an audit. There was a forensic audit. There were two forensic audits that occurred in February of this year, from February 2nd to February 15th. Two different forensic audits of the election tabulation equipment occurred. The plaintiff has, in its briefing, and also here today through counsel, has accused the county of rushing the audit to try to get it done before any type of legal relief could be granted by this court. There's simply no evidence for that, Your Honor. And furthermore, that wasn't pled in the complaint. That's not something that the court has to regard as true for purposes of the motion to dismiss. But there's no evidence supporting that contention. In fact, as we point out in our reply brief, the evidence actually cuts the other way. The county did not rush to complete the audit. The Libertarian Party knew as of February 2nd that it was not invited to the audit. That was the day that the audit started, February 2nd. And the plaintiff included two exhibits in its complaint that go directly to this point. One was an email from the chair of the Maricopa County Libertarian Party to the elections department, several people in the elections department, one of whom was Mr. Ray Valenzuela. And the chair of the Libertarian Party asked, why didn't you invite us to the audit? Or something to that effect. And Mr. Valenzuela replied that same day, February 2nd, the day that the audit began, and said, we made the decision not to invite the political parties. They weren't invited. But you can observe if you want to via the online feed, which is open to the public. So the party was on notice since February 2nd. They waited for whatever reason until February 9th. And they certainly had the right to do that. The plaintiff is the master of his complaint. The plaintiff can file his complaint whenever he wants to. But by waiting till February 9th, one audit was already done. And the second audit was underway and, now is complete. We can, I suppose, sit here and go back and forth, plaintiff's counsel and me, regarding, whether Title 11 gives the Board of Supervisors the authority to conduct an audit of its property that it leases. We certainly think it does. Title 11 gives broad governing power to the Board of Supervisors, and we cite that statute in our papers, Your Honor. Mr. Kielski is correct. This audit is not one of the Title 16 audits. It's simply not contemplated by Title 16, but that doesn't mean that it's illegal, because there's another provision of law in Title 11 that gives the Board of Supervisors the authority to govern the county and to take the steps necessary to govern, and that includes the steps that were taken to conduct these forensic audits to make certain that the property that it leases from Dominion Voting Systems, which has been the subject of numerous rumors and innuendos, to make certain that that property is functioning properly. The board had the right to do that, and it did. That leaves just one thing that Mr. Kielski said that I feel like we ought to respond to, and that has to do with the press releases that went out from the county that said that political party observers would be invited to the audit. And I think we need to be clear. There were press releases before the audits took place that said that the political party observers would be invited. There were social media posts on the day that the audits started that said both parties were invited. And Mr. Kielski, for the plaintiffs, has grouped both those together. I think they ought to be understood separately. I think that both parties referred to the fact that the Senate and the House were invited to attend the audit. But the pre-audit press releases did say that the political party observers would be invited. Plaintiffs are correct about that. That was a misspeaking. That was a mistake. But regardless, a press release and social media posts do not create a legal right. This is a matter of law, Your Honor. It's not about what was said on social media. It's not about what press releases were issued. This case is about, does the Libertarian Party have a legal right to attend the forensic audits that occurred in February of 2021? And press releases don't create a legal right. Social media posts don't create a legal right. Statutes create a legal right. The Elections Procedures Manual creates a legal right. But unfortunately for plaintiffs, neither the statutes nor the Elections Procedures Manual created a legal right for the plaintiff to be present at these particular audits. In fact, the Elections Procedures Manual expressly creates a carve-out whereby additional post-election audits after the ones that are required by statute may be conducted by the counties at their discretion, including with political party observers. And by the language that it uses, including with political party observers, it necessarily means that you can do them with or without. It's up to the counties. It's in their discretion. The county exercised its discretion not to include political party observers. The court might have an opinion as to whether that was a good public policy move or not. But that isn't the question. Nor is the question, did press releases get issued or social media posts? The only question is, does the law require the county to invite the political party representatives? And in this case, Your Honor, the law did not require that. Maricopa County acted within its authority under the law. And as a result, this matter should be dismissed. At the very least, Your Honor, if the matter does go forward, I do want to point out, as we said in our original motion, there are some defendants who had no responsibility for the audit, had nothing to do with the audit, and they should definitely be dismissed if this court decides to deny the motion and set this matter for an evidentiary hearing. And with that, Your Honor, again, I'll be happy to take any questions you might have.
All right, thank you. I will take the matter under advisement. I appreciate the arguments that were made. I will go back and review the authorities that were cited and issue a response or an opinion as quickly as I can. Mr. Kielski, was there something else that we missed?
Yeah, Judge, I just wanted to make sure that the court is not confused about something Mr. LaRue just said. Mr. LaRue seem to say that the plaintiffs agree that this was not a Title 16 audit. That's not what we argued, and that's not what we say. We again want to focus the court on the language that we quoted from the Elections Procedures Manual, that the defendant somehow interpreting the including with participation from representatives of the recognized political parties and turning that on to its opposite meaning. That is the type of audit the county here conducted. It is covered by the Election Procedures Manual, which is statutory authority for that is Title 16. We have never acknowledged, we don't agree that this is outside of Title 16. So I just wanted to be clear on that in court, in case the court thought Mr. LaRue was stating some kind of an agreement with plaintiffs on that point.
All right, thank you for that clarification. With that, unless there's anything further, this matter is adjourned. Thank you all.
Thank you, Judge.